we move on to our final speaker, Lord Beckett. Before becoming an appeal court judge, Lord Beckett was the administrative judge for first instance crime, so has significant experience of case management, sentencing, and how mental health issues impact upon the trial process as a whole. Lord Beckett.
Well, good afternoon. I'm going to start by ingratiating myself with my host by explaining that, well, in practice, judges do apply the sentencing guidelines, particularly the generic ones. Amongst the principles the Council identified in its first guideline is the need for a judge to consider all relevant circumstances, including the offender's circumstances, and that includes general capabilities as well as physical and mental health. The Sentencing Process Guideline is a synthesis of sentencing practice as it has developed over time and statutory requirements. It identifies culpability, blameworthiness, as one of the key considerations alongside the harm caused. It identifies features that may diminish culpability, specifying, amongst other things, youth and immaturity in a non-exhaustive list, but also specifies mental illness or disability, especially where linked to the commission of the offence, and the offender has demonstrated a willingness to address, amongst other things, mental health issues. So these are listed under generally mitigating factors, and they've been long recognised in sentencing practice, but I would caution that their significance must always be carefully evaluated in light of the circumstances of the particular case. Sentencing judges also find guidance in reported appeal decisions, publish sentencing statements of their colleagues, and in materials issued to judges by the Judicial Institute, the provider of judicial education on behalf of the Lord President. The prevalence of neurodivergence, learning disabilities, and other mental health issues, I was going to say to you, in my judgment, are almost certainly underrepresented in those cases in which I learn of them when passing sentence. But I've learned this morning that's undoubtedly the case. I'm just going to focus on practical examples from my own experience. As it happens, they're all High Court cases, and that's just because that's where these issues are most often raised before the court. For those of you who've had the dismal experience of listening to a lawyer telling war stories and found it deeply wearying, please feel free to zone out now for the next few minutes. For anyone interested, I'll reproduce my paper to the Council with a link to the various sentencing statements I refer to. It is less common for these conditions to feature in the Sheriff Court, and Lord Carloway, first thing this morning, gave us one of the reasons why. I think it's common for sheriffs, but I was one for a while, it's common for sheriffs to be told by a solicitor, usually without any specification or supporting material, that there are concerns about an accused person's mental condition. These may emerge in a social work report with or without vouching. But in the vast majority of cases, I think it is correct that there will not be any condition capable of meeting the criteria for intervention under Part 6 of the 1995 Act, with the politically incorrect name mental disorder. But that's not all that's in the judge's toolkit, because sections 227R and 277R and 277S of the 1995 Act provide for a mental health treatment requirement under a community payback order alongside a supervision requirement. The threshold is lower than under Part 6 of the Act, and evidence can come from a single registered doctor or psychologist, where the latter is to provide the treatment. A community payback order can also include a programme requirement, a residence requirement, drug treatment requirement, and an alcohol treatment requirement. So those theoretical resources are there. Whether the resources are there in practice, the Sheriff's present will no doubt have a view on that, but the law allows for them. As we've been hearing, the mental health issues focused on today can bear on the extent of a person's culpability, reducing the justification for punishment and indicating leniency. But protection of the public may weigh heavily on the other side of the scales. A culpability reducing condition may increase the importance of protecting the public from serious harm. It may necessitate a substantial prison sentence up to and including an order for lifelong restriction available on a range of crimes involving serious risk of harm, but not murder. Let me illustrate. A jury found a man who was charged with murder guilty of culpable homicide by reason of diminished responsibility. He had repeatedly hit his sleeping brother on the head with a hammer. Psychiatric and psychological assessment offered no route to address the serious danger he posed on account of a personality disorder. There was no recommendation for hospital treatment, despite a plethora of reports from psychiatrists and psychologists. I made a risk assessment order and got a report directed to that issue from a forensic psychiatrist and made an order for lifelong restriction with a punishment part of 3 years and 7 months. Now, I got a very dark look from experienced senior counsel, no names, Donald Finlay, who thought that having achieved the great success of acquittal for murder, his client would be treated leniently. In one view he was, but of course he may never get out. That's the nature of that sentence. But there was no other way of protecting people from this man, according to the information I had. In other cases, the identification of a condition, particularly if treatable and the accused is amenable to treatment, may render rehabilitation a prominent consideration. And that's important because successful rehabilitation can be the most effective and most proportionate way of protecting the public from serious harm. And it's one of the key purposes of sentencing identified in the first guideline. A practical problem for juries is the interrelationship of the short-term effects of willingly taken intoxicants, notably alcohol and cocaine, and a mental condition. And Lord Carloway mentioned this morning. That can make the issue of diminished responsibility very difficult for the judge and jury at trial, but it is usually resolved by the time of sentencing. There was a case where the accused had murdered his 2-year-old son in a state of self-induced intoxication caused by heavy drinking, along with grossly excessive amounts of prescription drugs. He appeared motivated by spite towards the child's mother, his former partner, and the jury rejected depression and personality disorder advanced by different psychiatrists as diminishing his responsibility. The point in his appeal was whether the sentencing judge, okay, it was me, should have given more mitigating effect to the appellant's diagnosis of depression. And the appeal court observed that where the jury had rejected depression as amounting to diminished responsibility, it had little residual mitigating weight, and it was for the trial judge to evaluate. And in that case, quite a long punishment part for a particularly cruel and determined murder of a defenceless child, the appeal failed. There was a very notorious case of double murder in 2023 where the accused was found guilty of murdering a young mother and her 2-year-old daughter, amongst other serious crimes, including serious sexual abuse of young children and a determined attempt to defeat the ends of justice by secreting the remains of his victims under his kitchen floor. He sought to establish diminished responsibility on the basis of a steroid-induced psychosis in circumstances where the only psychiatrist to give evidence rejected there being any mental condition which substantially operated at the time of the killings. The psychiatrist conceded that the accused may have high-functioning autism, but it didn't bear on his criminal responsibility. Whilst that condition barely featured in the evidence, once convicted, counsel said, almost in passing in mitigation, that a diagnosis of autism spectrum disorder was a mitigating circumstance, but no real attempt was made to explain its impact. I did have sight of a report from specialist psychologists suggesting that generally autism could reduce culpability, but no attempt was made by them to relate it to the circumstances of the accused and what he did. I concluded and explained in sentencing that in light of the evidence, I just didn't find any material reduction in culpability by virtue of that potential diagnosis. And he also appealed against sentence, and one of his grounds was a failure to give weight to the mitigating implications of his autism. He didn't get leave to appeal. The appeal judge is not being impressed by the proposition. Of some relevance to something we heard earlier is that the psychology report did disclose that for a Scottish prisoner such as him, there still can be limited provision following assessment. A prisoner can be transferred to a specialist unit in Wakefield Prison if it was relevant. My last war story is told with a view to illustrating pitfalls for the unwary from whichever side of things you may come. And it flows from a case in 2020 when an adult woman found to be of normal verbal intelligence faced a charge of culpable homicide. The prosecution accepted an unusual plea of guilty to a lesser charge. It was willful mistreatment and neglect of a child causing the death of her 13-year-old daughter. Now, the lawyers in the room might think that sounds awfully like culpable homicide. Never mind. It was proceeded with under a statutory provision concerning ill treatment and neglect. The child died of an untreated perforated ulcer, the symptoms of which were presenting for days. The Crown reached a pragmatic view, to be fair to them, at a time that was the start of the pandemic. It meant early resolution of a case in which a very large number of doctors could easily have had to testify. And that followed receipt of a defence report commissioned from a psychologist who proposed, on the basis of medical notes, that schizophrenia played a part at the time of the crime. And he also postulated that the implications of a childhood brain injury would include an inability to pick up and assimilate subtle signs of developing illness. It became readily apparent that he didn't actually know the full circumstances of how the child died as they were related in court to me when she pled guilty. I was troubled when I learned that the Crown, the prosecution, had not carried out their own psychiatric assessment before accepting the plea, and I was certainly determined that the court would need advice from a psychiatrist so that I could properly understand the implications of the accused condition. It was quite difficult to find someone, and it took quite a long time to get it done, but I was favoured with a very balanced, careful and insightful report revealing no psychotic symptoms at the time of the offence. But the psychiatrist passed on further input that she got from a neurologist, and in due course a helpful telephone conversation with the psychiatrist revealed that further neurological investigation wasn't going to help. The defence urged me not to send their client to prison given the psychologist's conclusion of a profoundly diminished culpability. I was armed with an understanding of the whole circumstances, and I accepted there was a brain injury and its effects did bear on the appellant's culpability to some extent, but there was no psychosis. The difficulty for that accused was that in the circumstances preceding the death, there was nothing which required complex processing of the sort envisaged by the defence psychologist. Her daughter was demonstrably extremely ill, was screaming in pain that she needed an ambulance, begging her mother to call one. The accused refused. When a neighbour called a taxi to take the child to hospital, the accused sent it away. And sad to say, the picture disclosed was that she didn't want her plans to have drinks with a male friend on a sunny afternoon disrupted by a trip to hospital where she would know that her appalling neglect would become apparent. I did impose a prison sentence shorter than it would otherwise have been because of the modestly reduced degree of culpability revealed by the whole circumstances, and leave to appeal against sentence was refused. So my conclusion from all of this is that input from doctors and psychologists can be essential in sentencing, but professionals must be scrupulous in confining themselves to their specialism and careful not to make unwarranted assumptions about the circumstances. And judges must be astute in evaluating specialist opinions in light of the law and the facts of the case on which the court is bound to proceed. Thank you.